On our very first episode of Drugs on the Docket, Mark Osler unpacked some of the United States Supreme Court cases that shaped U.S. federal sentencing guidelines and practices. One of these cases, United States v. Booker, was supposed to have fixed the sentencing guidelines and put to rest persistent questions about their use. Specifically, Booker rendered the guidelines advisory as opposed to mandatory. It's been 20 years since the Booker decision was handed down. So what can be said about its impact on federal sentencing practices? Does the data tell a story of consistency and fairness? Or did the Booker decision result in, as Justice Scalia put it in his dissenting opinion, a discordant symphony of different standards? From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller. In this episode, we're examining the legacy of United States v. Booker. If you like what you hear in today's episode, visit go.osu.edu/drugs on the docket to follow the series. Well, the decision that made federal sentencing guidelines advisory turns 20 years old this year, so we've invited Doug Passon and Mark Allenbaugh back to discuss federal drug sentencing trends since United States v. Booker was brought before SCOTUS, and dive into some other interesting stories related to the guidelines and federal sentencing, including legislative changes that took place in the last 10 years and commutation activity at the end of Biden's presidential term. So, Doug, I would love for you to get us started, and I have to ask the very basic question. What was Booker?
Thank you, Hannah, and thanks to Doug and Mark for joining us. There's so much here, although I will start with the idea that Booker is kind of now both the loved and hated child, one that very few people showed up to its 20th birthday party. It got very little attention. Now, I think that's partially a function of an awful lot else was going on in January 2025. But the reason Booker is, I think, rightly thought of as loved and hated is because for an awful lot of people, Booker marked, when it was decided January 12th, 2005, this really seismic change, at least atmospherically, in the operation of the federal sentencing system, because Booker was the culmination of a series of Supreme Court constitutional rulings that fundamentally had to do with whether and how it was appropriate, when it was appropriate for judges to find facts at sentencing, distinct from when a jury is involved or when a defendant admits to those facts in the process of a conviction. And the reason this was such a big deal and the reason it's really consumed my professional life is an awful lot of sentencing law, which got developed in the late 20th century, was built around the assumption that it was entirely appropriate. In fact, the sensible way to run a sentencing system, to have judges find the facts at sentencing, in part because that's historically what they always did. And in many respects, when we're talking about facts related to the offender that are often very relevant at sentencing, that made an awful lot of sense. Let's imagine the defendant, this comes up in a variety of settings, they had a terrible childhood. And the reason they turned to crime was they grew up poor or without housing or had other kinds of abuse. And that's why they got started doing drugs or being involved in selling drugs. Or let's imagine they had a drug addiction that itself contributed to being involved in a range of possible crimes. So many of those kinds of stories, the idea that that would be presented at a trial or that would be part of the conviction seemed, no, that's what the defendant tells the judge, and the judge makes findings and makes judgments at sentencing. That all seemed very logical. What created tension and ultimately led to the Booker decision, and I'll shut up in a minute to let Doug and Mark chime in as they see fit, is as sentencing systems were being constructed in the late 20th century, there wasn't actually that much attention given to, well, what are the mitigating factors relating to the defendant that a judge needs to look at? Instead, an awful lot of attention was given to, well, what are the potential aggravating factors involved in the crime itself? Did the defendant have a gun when they were doing that drug sale? How many drugs were involved in that sale? Oh, they did a bank fraud. How much money was involved in that bank fraud? Those all seem like relevant factors for deciding how bad a crime is. But once you start having the judge make those findings, it seems to start invading what we think of traditionally as the province of the jury. Finding facts about the crime, that all seems to be something we think juries are there to do. Did the defendant actually do it? And what did they do? And yet, sentencing systems got very much constructed around the idea, especially in the federal system, that it's not only appropriate but necessary for the judge rather than the jury to be finding these facts. And then last but not least, this gets extra complicated because, of course, very few cases actually go to a jury. More often than not, in fact, 95 out of 100 cases get resolved through a guilty plea. And oftentimes that plea can sometimes involve the defendant admitting to certain facts, but sometimes it can involve the defendant either not addressing certain facts about the crime or even disputing certain claims by the prosecution. How should that get resolved when we're talking about a guilty plea rather than a traditional trial? All of that culminates in a Supreme Court ruling in Booker that ultimately says it's inappropriate for judges to find facts that increase the defendant's sentence as a matter of law. If the law says, judge, you have to find this fact, and that's going to increase the sentence automatically, or the range of sentence automatically, that's what the Supreme Court said is inappropriate. But then they said, much to everybody's head-scratching reality, oh, it's fine, judge, if you do that, as long as you're only increasing the advice of what sentence you should give. If the guidelines are advisory, they don't make you increase the sentence. They just suggest that you increase the sentence, but then you still have authority to not follow that guideline, then you can find all the facts you want. And for the last 20 years, we've been trying to figure out what that means and how that actually impacts federal sentencing. And I'll conclude by saying among the things we've done to try to celebrate Booker, whether it's worthy of celebration or not, is have a forthcoming issue of the Federal Sentencing Reporter that I'm fortunate enough to help out with, try to look at, well, what have we learned? What is this case about 20 years later with some hindsight? Has this improved the federal sentencing system or not? It certainly has confused the federal sentencing system. And with that lengthy overview, I kick it to Mark or Doug either to dispute or question or supplement my background description, but also to just give their general sense of, are we in a better place now than we were 20 years ago when this Booker decision first made the guidelines advisory?
Well, I do have a very direct question. I mean, I know that Doug Passon works with defendants at time of sentencing to present mitigating factors for the judge's consideration. So for Doug Passon, whether it be drug cases specifically or other cases you might work on, have you noticed any unintended consequences to the Booker decision and its impact on just the federal judicial system generally and how these cases are handled now?
I think I'll answer the question a little more broadly, which is to say, I've had a love-hate relationship with the guidelines since Booker, or I have a love-hate relationship with Booker in general. Let's put it that way. On the one side, as Professor Berman mentions, this was kind of a sleight of hand workaround where we're all saying these guidelines are really not constitutional because the judge can find all these facts. And by the way, at trial, we know the standard of proof is beyond a reasonable doubt. Not so. Preponderance of the evidence. So it's very, very, very easy for a judge to find all these facts and enhance a sentence through the roof. That's totally unconstitutional, but that's okay. We'll just make these advisory and still let the judge do that. And so that nothing really changed in the constitutional deficiency of the guidelines, in my opinion, because the judge still can find these facts and the guidelines go through the roof, especially in drug cases. And then our major monumental task is to say, well, great, we have the guidelines that, require a life sentence, and there is still some anchoring effect of the guidelines. And now I have the monumental task of trying to convince a judge why they should now vary, because they have the discretion, down to 5 years or probation or whatever. So it's often not an easy task. The guidelines are still a high hurdle. So that's my hate part of the relationship with Booker. I just don't think it was a genuine fix. But the love part is, making these discretionary has been a huge benefit. I started my practice in federal court in 2002. So I was, I had a few years under the old system. And once the new system came in place, it did feel like I had the shackles off. And because I am the storyteller and I'm the guy that says, you're not sentencing a crime, you're sentencing a human being. And you better look at the whole life's arc of a human being to decide what is a just and fair sentence. And 3553 became the real meat and potatoes of my practice, and 3553, it says the judge must consider certain criteria, the most important of which are the history and characteristics of the person who is before the judge for sentencing, which is my bread and butter. I want them to see the human being, and also the nature and circumstances of the offense. There are other factors too. We could spend 6 more podcasts talking about my thoughts about some of these other factors, like the need for unwanted sentencing disparity and promoting respect for the law and all that. But those are the 2 big ones: nature and circumstances of the offense and history and characteristics. And that just allows us to get away from the guidelines, focus on the human story. And so that's why I do the videos, and it's why my podcast, I say my studio is 3553. I mean, that's everything to me. But I still have a huge problem with the fact finding, especially with the low burden of proof.
So there was definitely a vibe shift after Booker, but Mark, was there a number shift?
One of the big criticisms of the guidelines prior to Booker was that the guidelines were calibrated too high. And when I say criticism, I mean from federal judges from across the political spectrum, not just for drug traffickers, but other types of offenses, fraud offenses, even child pornography offenses. But now, once the shackles were taken off, so to speak, with Booker, one would have expected some dramatic decreases in the average sentences and the median sentences. And we didn't see that. Even though from a 50,000 foot perspective, it looks like there's still some uniformity and the guidelines seem to anchor some sentencing. The story gets interesting when you start to drill down in the data, as it always does. And there we see some significant differences. So, for example, drug trafficking, the average sentence back in 2003 was 87.2 months, and it was only 82 months in fiscal year 2023. The average went down slightly, but the median, which is probably a better statistic for indicating central tendency, increased significantly from 57 months to 63 months. And that is a significant increase. Even though it's only 5 months, that's almost a 10% increase in the median sentence. And there's other variations there too. I always like to point out something unique about Booker, that it's the only Supreme Court decision with 2 majority opinions. So we had the constitutional opinion in Booker that said the guidelines as binding was unconstitutional, violated the Sixth Amendment. But then there was the surprise remedial opinion, which nobody had even briefed or argued, and something that the court on its own came up with. And the remedial opinion said, to get around the constitutional problem, we're just going to make the guidelines merely advisory. Scalia said in his dissent to the remedial opinion, we are going to be in for a discordant symphony of sentencing, because if the guidelines are merely advisory, then judges are going to be sentencing all over the place. And guess what? That is exactly what has happened.
I'm going to jump in on this and answer your question, Hannah, to some degree, to kind of capture a lot of these themes, because it's been some of my reactions to watching Booker play out over the years. First, there was a lot of criticism of the guidelines writ large coming from federal judges. They were very outspoken, particularly early on when the guidelines made them feel as though they lost an extraordinary amount of discretion. So the early generation of judges dealing with the guidelines were very vocal. Drug cases were particularly a place for their vocal concerns about mandatory minimums and really long sentence lengths, though it's easy to forget that there's close to 700 federal district judges. And so when you see 5 or 10 or even 30 judges complaining about these guidelines, it's often a story of these are the ones who want to be vocal, not necessarily representative that they all think these are misguided. In addition, they're often vocal about that one, not necessarily outlier case, but extreme case where they really had to hammer somebody under the then mandatory guidelines or under mandatory minimums, where it looked like a lower level offender. Even the judges complaining about having their hands tied often would then, once they were free to use their discretion, would still find in, a majority of cases, even if they weren't going to follow the guidelines, they weren't going to vary off those guidelines dramatically, because when they were complaining about the drug guidelines, it was that occasional low-level person getting hammered, not the person that the government was bringing in involved in lots of drug activity and otherwise seeming to be a more serious offender. Then I think, and this is maybe a little bit of a question for Doug and Mark, although this goes back a long time, there was a lot of discussion right after Booker was decided that the government would kind of up their game in bringing aggravating factors to the attention of the judge. That one of the things that a mandatory guideline system, and to some extent I think this is true for mandatory minimums even today, allowed the government to be is a little bit kind of lazy. If I can just bring in and put in front of the judge that there was this amount of drugs involved, I'm going to get a high sentence. And I don't need to develop for the judge an elaborate story of the guy also did this to his kid and also did that other thing to intimidate these witnesses and bring in all these other aggravating factors. One of the things that I sense, though, I'd love to hear from Doug or Mark on this question. 3553A not only creates an opportunity for defense attorneys to tell mitigating stories that aren't inherent necessarily in the crime itself, but it also creates an opportunity, arguably an obligation of prosecutors to bring forward aggravating stories and to thicken their account for why they chose to go after this person and try to hammer them at sentencing. And my sense, generally speaking, is prosecutors now, 20 years later, understand it's not enough just to kind of check the boxes to get a severe sentence. They're going to have to tell more of a story. They're going to have to dispute more of the defense's story. I think all things considered, that's a good net for the system, right? That more relevant factors are coming to bear and being introduced to judges. But oftentimes federal prosecutors, I don't want to say uniquely in drug cases, but in a lot of cases, they're already screening, or at least they think they're screening the less severe cases. So if they're even bringing the case, and especially if they're seeking a long sentence, they often have a file that they think can make for aggravating arguments. Or it's important to keep in mind, since an awful lot of judges are former prosecutors, there's an assumption at times that there's even more aggravating factors behind a particular case. And I think that itself may somewhat shape what Mark was talking about, that our averages may end up more or less the same, but that may be a product of the 3553A conversation about what sentence is sufficient but not greater than necessary is richer now than it was back when the guidelines were mandatory and everybody was stuck following the boxes. But maybe that's an ivory tower academic's hope that the system is functioning more functionally.
I can tell you my experience almost universally is that 3553 has almost exclusively been a very valuable tool for the defendant to achieve a lower sentence. And Mark can tell you the statistics till Tuesday, like that, variances are more common than a guideline sentence. But the reason why I don't think prosecutors really are using 3553 as vigorously as the defense side, because they don't have to. The guidelines still allow them to be, I don't want to be disparaging, but essentially lazy, because the guidelines are what they are. And again, they know the standard is preponderance of the evidence, so they don't have to put on a huge dog and pony show to prove an enhancement. And sorry to say, they have a co-conspirator in this process, which is the probation officer, because they're doing a pre-sentence report and they're doing the guideline calculation. And more often than not, they're throwing in every guideline enhancement that they think applies. So you're walking in the sentence with a huge headwind, which is you're trying to object to this guideline and that guideline and everything else. And the prosecutors know that, whatever the guidelines are going to be is plenty enough for them. And they don't have to go out of their way to try to get a lot of enhancements. They are almost exclusively, though, arguing for guideline sentences in every case, unless you have some plea worked out for a different result. So they're just still very, very anchored into that system. Our job is to, move the judge. And a lot of times I'm done with the prosecutor at a certain stage because I know I'm not going to influence them. They're going to ask what they're going to ask for. And the judge is my audience of one. But I also have to throw in this little thing. We're having this great discussion about the guidelines, but we're doing it in the context of drugs on the docket. And it just strikes me that we have to point out that it's a very different calculus when you're talking about drug crimes, for the simple fact that they're mandatory minimums. And that is the ultimate authority that rests with the prosecutor. They can charge a mandatory minimum or not. They can charge an 851 enhancement if you have a prior drug case, which then boosts the mandatory minimum up to 20 years. And that's not discretionary. So once that comes on the table, all bets are off when it comes to the guidelines. So there's this huge tug of war between the guidelines, mandatory minimums, prosecutorial discretion, 3553 factors, and the like. I just think if you look at the guidelines trajectory of life after Booker, all those things I said after guidelines, mandatory minimums, prosecutorial discretion, 3553, they all trump the guidelines. I mean, they're all more powerful and more important and more legally relevant than the guidelines. So you would think that the guidelines would be disappearing into a fog off in the distance. But we talked last time about them being the drunk uncle at Thanksgiving because they don't really give good advice. I mean, maybe this is my wishful thinking, but I think they're moving from drunk uncle to bastard stepchild because I just feel like each passing year they become less and less important in this calculus. And who knows, there may be even more once the next cycle of amendments come and they do away with all the all the departures.
That's it. But I think you're right on that, Doug. I think the guidelines actually are disappearing in effect, and the commission is starting to recognize that. What I'm referring to is this new simplification of the three-step process that the commission has proposed to get rid of all departures. And the reason why is because of all these variances that occurred. These were basically reasons that courts could give to sentence outside of the guideline range that wasn't otherwise accounted for within the guidelines. So when the guidelines were binding, courts had to first consider that particular range. And then there was a chapter in the guidelines that said, in very rare circumstances, you could depart outside of the guideline range, but these were very rare circumstances and very well articulated circumstances. After Booker, now departures basically became an anachronism, essentially, because now judges weren't limited by the departures. They could sentence outside the guideline range for any reason, including, the Supreme Court said in Gall, if they had a policy dispute with the guidelines or a disagreement with the commission, they could sentence outside those guideline ranges. So over the last 20 years, the whole nature of departures have become largely irrelevant, and in its place have been variances, or what the Dougs have referred to as the 3553A factors. So what the commission has finally decided to do, or is proposing to do, is say, hey, let's get rid of all this departure stuff and just focus on variances. But what's so significant about that is the reason that they give. And if I could just be indulged for a second to read a little bit of their reasons that they give for why it makes sense to get rid of departures. Part B of the proposed amendment would delete most departures currently provided throughout the guideline manual. Changes would be made throughout the manual by deleting the departure provision currently contained in commentary to various guidelines. The new background commentary concludes by noting that the application instructions set forth in 1B 1.1, how to apply the guidelines, are structured to reflect the two-step process in which the sentencing court must first correctly calculate the applicable guideline range as the starting point and initial benchmark, and then must, not should or may, but must determine an appropriate sentence upon consideration of all the factors set forth by Congress in 3553A. Now, I'm just reading just a small portion of the reason for this amendment, but what the commission earlier says is that when the guidelines were first created, Congress hamstrung the commission by stating there were certain factors that the commission could not consider in promulgating the guidelines. And those should have been considered according to the commission and must be considered as 3553A factors, even though the commission is still hamstrung by Congress because Congress never picked up the ball after Booker and fixed the guidelines, by the way, or gave the commission permission to fix the guidelines to make them compliant with Booker. What the commission now is stating is the guidelines are as they are constructed because Congress hamstrung the commission. They are incomplete. And not only are they incomplete, they're incomplete in the sense that they do not, by their very nature, take into account all factors that should be taken into account when imposing a sentence.
It is itself an interesting reality of the 20th anniversary of Booker that it took 20 years for the commission to find the ability and the interest in finally acknowledging in a formalized way that Booker has dramatically changed federal sentencing. And I think that there's a yin and yang to all of that. I think the commission's failure to do that is one of the things that has kept the guidelines so central, kept some of those average sentences where they were, still give the gravitational force to the guidelines in a variety of ways. I'd also want to emphasize, and it's itself real interesting, particularly for the drug sentencing space, that another aspect of what the commission has proposed to do in this amendment cycle is to try to de-emphasize the weight of the drugs in some guideline amendments, but that de-emphasis is not what I think many would call for, myself included, which is a complete elimination of using drug weight as a central factor in deciding what the guideline range would be. They're being attentive to literally multi-decade concern. And of course, this is where these things all move together in terms of what Mark was talking about and hamstrings by Congress. Congress has pegged these mandatory minimum to drug weights. And so the commission, I think understandably, but still problematically, has felt bound by that choice by Congress, even though there's very little evidence that that choice by Congress has made any policy sense. I'll add on to this, especially because we're talking now, a few weeks after a change in administration and a change in Justice Department leadership. One thing that's very much influenced everything that judges do pre-Booker and post-Booker, one thing that especially relates to what Doug was talking about with mandatory minimums, relates to the charging policies and plea policies of the Department of Justice. And for many, many years, the severity of the system has been driven in part by internal Justice Department guidance that says always seek the most severe charges, the most severe possible sentences, often defined by applicable mandatory minimums. During the Obama years, Attorney General Holder issued what was a very significant memo and seemed to have a real impact in charging and bargaining practices by saying expressly prosecutors on the ground have more discretion to decide whether a mandatory minimum or a severe guideline sentence would be too extreme. Attorney General Garland during the Biden years seemed to follow up on that, although somewhat less clearly or effectively as might have been done. But ultimately, we've now in a Trump era with Attorney General Bondi, and she has, and DOJ has now back to that policy of pursue and always seek to get the most severe possible charges and sentences. And again, talking about drug guidelines, as Doug highlighted, without being attentive to that shadow reality or that really, sentencing reality that if DOJ decides to bring a mandatory minimum charge and pursue it because they're based on drug weights are what's going to matter, though valuably after Booker, you at least need to prove those drug weights beyond a reasonable doubt to a jury if you're going to get the mandatory minimum applied. But ultimately, that's usually of little comfort, both when there's the threat of even a higher sentence if you go to trial and contest the drug weights rather than plead guilty and potentially get benefits under some safety valve provisions. And again, all of those details are always going to be dependent on how prosecutors use their discretion even before the case comes before a judge, and then potentially limits the discretion the judge has to go below the guidelines.
The Fair Sentencing Act in 2010, that reduced the ratio, but it didn't reduce it 1-to-1, right? It was like 100-to-1, then it was 18-to-1.
Correct. And I'll happily go law professor and say what Hannah's talking about so valuable is the biggest first change in drug sentencing in the modern era, and a real important signal that we weren't always going to be driving our sentences longer and longer was the decision by Congress in 2010 to reduce the severe 100-to-1 crack powder ratio in our mandatory minimums and in our guidelines. But even though the commission years earlier had said it should be 1-to-1, it's the same drug, Congress only got around to reducing crack sentences partially, so they're not 100 times less weight to trigger these mandatory minimums. It's only 18 times less weight. We have an 18-to-1 ratio so that you still get a much more severe mandatory minimum, a much more severe guideline range based on crack as opposed to powder, but not as extreme as it was prior to the Fair Sentencing Act when it was a 100-to-1 ratio rather than the current now 18-to-1 ratio.
We know that prosecutorial discretion in terms of bringing a mandatory minimum, putting that on the table, be like, hey, we're just going to charge you the mandatory minimum. But they could say, take this plea deal or we will charge you the mandatory minimum. Is this the instance, Mark, you were saying where what the Sentencing Commission realized maybe is, or had they already said like, okay, Congress does not have the balls to go 1-to-1. But if prosecutors aren't bringing the mandatory minimum to the table, and there's a situation where you could get to the judge and say, hey, you can minimize the importance of the weight, even though Congress will not make it 1-to-1, we can just diminish the importance of the weight for sentencing purposes, so long as the prosecutors have not brought mandatory minimum charges.
The mandatory minimums always trump the guidelines, so there's nothing that the commission can do about that. It's very sophisticated how the guidelines work calculating the drug amount. So I got to see how expansive the change in the calculation is. Professor Berman, do you know, are they limiting this change just to crack?
It is very complicated. I want to put my finger, though, on, Hannah, you're raising really a big, broad point that in many respects explains why the system is the way it is. At the end of the day, none of these outcomes, whether it's the mandatory minimums, whether it's the severity of the drug guidelines based on weight or other factors, is really anything that ties the hands of prosecutors. They all become opportunities in the hands of prosecutors to threaten. Again, it would require to some degree that the person has, the underlying criminal activity, but the prosecutor's in a position to threaten. Often they're doing it in conjunction with trying to get somebody to cooperate and then rat out on the person they got the drugs from or somebody else that they're going after. And that's what leads prosecutors, generally speaking, to continue to advocate for tough sentences. It's not that they're saying, we think the sentences should be extreme in every case. What they're saying is, we think we, the prosecutors, should be the ones who get to decide who's subject to the most severe sentences and who gets a break, whether the break is justified by we want to get this person to help us make other cases, or we just think this person is more sympathetic for this reason or that reason, or they're willing to plead guilty quickly, or there's all sorts of factors that go into prosecutorial decision-making in this respect. That's the real key, though, is that I know that there are people in Congress who understand, hey, when we pass a mandatory minimum, we're not mandating that everybody gets this extreme sentence. We're just giving the prosecutors another tool to use to go after the bad guys. And again, an awful lot of those members of Congress had been prosecutors or hear from prosecutors who say, don't take away our tools. We're fighting the bad guys. We need every one of those tools in order to fight them effectively. And don't worry, you can trust us, the prosecutors, not to go after people who don't deserve it, right? And that's really what fuels the whole system, facilitates this level of severity that, again, gets mitigated in a variety of discretionary decisions by prosecutors, by judges, but ultimately not, to most people's view, especially if they work on the defense side, to really come up with truly just and sensible outcomes when we ultimately get to a final sentencing decision. And Doug, I know you do all this work all the time.
I think that's a good synopsis of how things were. But as you stated not too long ago, we're in uncharted waters now. It's a new administration. And you cited to their, the Holder memo is out there reverting back to some of these more serious practices. But it's worse than that to me. I mean, when I read this memo, it's saying, come at our clients with everything you've got and do not relent. And don't even relent in plea negotiations. I mean, if we look at this, it goes back to the core principle of charging and pursuing the most serious, readily provable offense. That's a quote. And then the policy goes further. I don't know if this was the policy before, but I think this is new. It provides that plea bargaining, which, as you mentioned earlier, is every case we have 95% of the time, is governed by the same fundamental consideration applied in the charging decisions, namely pursuing the most serious, readily provable offense. And the memo instructs these prosecutors to use those tools. In other words, it says, do not abandon pending charges in favor of a plea that is inconsistent with, quote, the seriousness of the defendant's conduct at the time the charges were filed. So the way I read that memo is smoke them if you got them, prosecutors. If you can hit them with a mandatory minimum, hit them. And if you can hit them with an 851 enhancement, hit them. And guess what? If you want to get rid of those in the plea bargaining, good luck with that, because you're going to have to do a memo to your boss and get a special consideration or deviation from the U.S. attorney to do so. And so I don't know how that's going to play out on the ground, but those are the marching orders. And we know who that's going to impact disproportionately: our Black and brown clients, who will be targeted, especially in the drug cases. And so I don't know how that's going to play out. But if that's the game they want to play, the only possible outcome that I see is if I have a client who's got charged with mandatory minimum and they want me to plead to mandatory minimum, then I guess we're just going to trial. Because who knows what happens at trial? Maybe your snitch doesn't show up or something happens and I can win this thing. So, maybe we're going to have to just shut the system down with more trials than they have the capability to handle. And maybe the judges will start putting these prosecutors back in check if they get out of line.
There's always jury nullification. I'm just kidding. I'm
But
kidding.
that's another problem. Guess what? You don't get to tell the jury, by the way, if you convict them, they're going to prison for 20 years, no questions asked. So that's another problem. But I don't know what your other options are if they're going to pursue these relentlessly. Because why would we ever plead our clients, just march them off to prison sentence for mandatory minimums of 10 and 20 years?
It's not like the federal prison system has lots of excess capacity, and there's been not only patterns of clemency that has helped a little bit or at least reduce the prison system. We had the COVID era that also has, to some degree, loosened up how many people were jamming into limited facilities. But ultimately, the Bureau of Prisons has run in less than inspiring ways, to put it kindly. And what this new administration is going to mean for all of that functioning, I think, is a huge open question that not only relates to what do we end up seeing with case processing, as you're suggesting, do we see more defendants go to trial because they can't get offered any benefits for pleading guilty, but also what happens on the back end if we have a mass increase in the length and number of persons being subject to sentencing. That I think especially true when we look at immigration cases. How many of these cases are going to be brought into the criminal system versus going to be handled other ways, given the increased enforcement that this administration has indicated an interest in. And so,
well, Professor Berman, there's always Guantanamo Bay if they're running out of room at the BOP.
It's almost funny, but it's not.
It's not.
And that's certainly true. And I guess I want to return to the drugs on the docket theme by highlighting that there's always a set of synergies here to some degree, that the system, even though how immigration cases get handled don't directly affect drug cases, it's the same sets of prosecutors with the same limited time and energy with, working with judges that are getting more or less frustrated with the way they're going about doing their business. And so I think folks who are focused on the drug side of things in particular can't ignore these sort of broader controversies and debates and uncertainties that are going to attend to just what the federal criminal justice docket and sentencing practice in particular looks like in the coming years.
This might be a very weak segue, but on the topic of federal capacity, the only way to make more capacity in our systems, if we do have the hammer of this new administration memo for prosecutors just go hard, is if you remove people from the current system. And Doug, I know that you were particularly interested in some of the executive decisions made at the end of Biden's presidential term in terms of clemency. I don't know how many of those were actually individuals who were able to walk out of incarceration, but I wanted to get to this topic because it feels like all of the legislative changes in the last 15 years have maybe been leading to at least an additional vibe shift that has enabled the type of clemency decisions that he made.
The Fair Sentencing Act, in some sense, triggered what has been now, over the last decade or so, kind of a modern resurgence of federal clemency, even though there's also lots of criticisms about that resurgence. In 2014, then President Obama created something that became known as Clemency Project 14, CP14, which was his indication after Congress had passed the Fair Sentencing Act, made crack sentences less severe, that didn't make those new sentences retroactive. In other words, folks who had been sentenced under the more severe 100-to-1 crack powder ratio prior to the Fair Sentencing Act were still stuck serving sometimes life sentences, sometimes 20, 30, 40 years, just incredibly long terms. And the Fair Sentencing Act had nothing for them, so to speak. And Obama said and instructed his Justice Department, screen cases for me of lower level offenders, folks who got sort of slammed by the severe crack sentences, and I'll consider commuting their sentences. And ultimately, through a very elaborate multi-year process, Obama left office with, I think it was 1,715 commutations he granted, at that moment, a historic record number. Among the things that did is get a lot of people sort of focused on how many drug offenders are serving extremely long sentences. There was a considerable effort in the first Trump administration to advocate for him to commute some more drug offense sentences because there were still plenty more in the federal system. He did about 100 or so, though a lot more cronies got clemency than drug offenders in Trump's first year. But then when Biden served his term, there was an incredible push to encourage him to sort of get back to these groups. And in fact, in a series of clemency actions, some getting a lot more attention than others, Biden really went out the door, and some getting more controversy than others as well, granting an extraordinary amount of pardons and clemencies The clemencies of particular note was about 1,500 or so folks who had been on home confinement after COVID got their sentence commuted. That got some attention because it was done a few weeks before he left office. But then literally 3 days before he left office, he then also commuted 2,490 drug sentences. And a lot of those folks are still serving time because they were scheduled to get released into 2025. But it's the single largest, to my knowledge, sort of mass, but not quite mass clemency commutation grant. And whether and how that will then facilitate, future action for these populations remains to be seen. I do think to some degree, Trump having promised and then delivering on the promise to commute and pardon so many January 6th offenders may have created some space for Biden before he left office to do this, what he called nonviolent drug offenders. But this is an area that I think is worthy of a lot more study and, among other things, would be eager for Doug and Mark's reaction to it. But it is a different version of sort of sentencing by presidential fiat, rather than by prosecutorial or judicial discretion.
So I think the funny thing is when we talked before and we were prepping for this and Professor Berman mentioned these 1,600 or so drug clemencies, I hadn't heard of that, nor had Mark, right? So this really, really went under the radar. And I was just doing a little Googling to see if I could get more info about it. And what I'm really, really needing to know is what were the criteria. Apparently, there's a process of the Office of Pardons in the DOJ. They recommended a certain amount of these for clemency, but President Biden went way, way further. I think there was only 10% of the people he pardoned were actually ones that the Pardon Office wanted pardoned. It looks like it was some people with pretty violent histories were swept up into this that got clemency. So much so that Liz Oyer, who was the head of the Office of Pardons, came out with a statement saying this is not the outcome we were looking for. So why? What happened here? Why was the president so intent on doing a sweeping pardon? Was it because of crack disparity? I think these were supposedly all crack cases. Was it because of the racial disparity? I don't know, but I think maybe someday needs to do a deeper dive into what these cases were and what was the criterion and the real motivation. We may never know.
Well, they couldn't have come at a better time, if nothing else, with respect to the Bureau of Prisons capacity. During the pandemic, all the private prisons were closed, and all those inmates that were in the private prisons, which were primarily foreign nationals, were moved into the Bureau of Prisons facilities, the ones that are actually directly operated by the government. Since that time, there have been several additional Bureau of Prisons prison closings. And the Trump administration has announced the additional closing of 6 prison camps, which is generally where you have your very low level offenders, generally your economic offenders, your first time offenders. But all those inmates need to be moved somewhere. So the capacity of the Bureau of Prisons has been decreasing dramatically over the last 4 years. And yet there has been nothing done by the Department of Justice to alleviate that inevitable pressure. And right now, I'm just looking at data. Almost every high, medium, and low security facility is over its rated capacity. The only facilities that are, generally speaking, under their rated capacity are the prison camps, but those are closing. So now we're going to have more inmates either stuffed into the remaining camps, or what actually did happen when the private prisons were closed is a lot of those inmates were moved into higher security facilities than they otherwise would have been, into the mediums and sometimes highs, because there's no room. The point simply is, regardless of the reason for these mass commutations, is a bit of a release valve. And I wonder how much that was on Biden's mind when he did this. It doesn't seem to me that the current administration has given any thought to that, especially with the Bondi memo. Now let's just go back to charging the most serious offense that we possibly can and maximize the sentence. They're going to make matters worse because there's no more room at the end.
Well, I will say when now AG Bondi gave her opening remarks at her confirmation hearing, she explicitly recognized that the Bureau of Prisons was broken and that one of her platforms was to fix it. So I don't know how she thinks charging more people with longer sentences is going to do that.
Exactly.
My guess is we'll see more private prisons. This is a follow the money situation. And There's great profits to be made in locking up offenders for long periods of time.
Yeah.
That will be the way they take the stress off of the Bureau of Prisons.
Yeah, but they can't build them fast enough. I think you're right, Doug. The closing of the private prisons, something that Trump opposed, started with the Obama administration because of just the inhumanity that these private prisons were treating inmates with. They were very substandard facilities, also overcrowded, staffed with individuals that were completely unqualified. Turns out the BOP is not much different.
Not at all different. Not at all different. It's worse right now, I'm sorry to say. It's the worst we've ever seen it. Anyone working in there would tell you that if they could.
You gentlemen have been incredibly generous with your time, and I'm going to sort of try to wrap us up by highlighting that it's, of course, fitting that we end with where, sentences end up, right? Sentences end up in the prison system. There's also the halfway house problem, right? Among the challenges is once you're brought into the system, even if you're not going to get a severe prison term, if there's an effort to do any kind of rehabilitative servicing or programming, that has a resource challenge as well. And so resources have a way of coming in one way or another. And I think that's another component of what I'm grateful for you all to sort of take the time today to help us start unpacking, which is just there's so many moving parts of the system, from thinking about, the Attorney General and prosecutors who themselves are either formally or indirectly taking cues from Congress, how that works through, the work of judges now having discretion after Booker, but not often exercising that discretion without still attentiveness to the existing guidelines, the guidelines themselves being proposed to change in a bunch of important ways to keep an eye on, and then, what that's going to mean for prison practices and policies that are, as Doug put it, the worst we've seen. All of that gives us lots to keep an eye on. I hope you both will come back. It wasn't 20 years since we last talked, but that's when Booker came down. But we'll have other anniversaries, good and bad, love-hate stories to tell. So thank you so much to both of you, and Ann and Holly, for your work in getting us together today.
Thanks so much for having us again, and thanks for all you do.
Yes, thank you.
Drugs on the Docket is a production of the Moritz College of Law Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt.